Court reporter has arrived. Good morning. We are on the record. Welcome to the Maryland Public Service Commission's proceeding in docket RM74. This is a rulemaking with respect to proposed regulations concerning vehicle inspection standards. By notice issued on August 5th, 2021, this has been noticed as the time and place for the Commission to consider these proposed regulations to its vehicle inspection standards for taxi cabs and transportation network companies. On August 2nd, 2021, the Commission staff filed draft regulatory text proposing modifications to the Commission's regulations. Interested persons had until August 26, 2021 to file responsive comments. The Center for Auto Safety and Lyft Incorporated and Uber Technologies Incorporated jointly filed timely comments. The commissioners have reviewed the proposed regulations as well as the responsive comments and will now hear from parties. I believe staff has a presentation to make, so I will now recognize our staff team. Good morning.
Good morning, Chairman and Commissioners. I am Catherine Mackerlane, Assistant Staff Counsel on behalf of staff. Also representing staff this morning is Mr. Kenny Albert and Mr. Komar, Mr. Christopher T. Komar, Director of Transportation, Mr. Mark Gorman, Assistant Director of Safety and Enforcement, and Ms. Regina Gee, Assistant Director and Administration on behalf of staff. RM74 is a rulemaking to consider revisions to the Code of Maryland Regulations, Title 20, Subtitle 90, Chapter 2, Regulation 16, and Title 20, Subtitle 95, Chapter 1, Regulation 11, governing vehicle inspection standards. The Commission's technical staff submitted a petition for a rulemaking to revise the Komar vehicle inspection standards on December 31st, 2020. Pursuant to Commission order issued on January 5th, 2021, the Commission directed staff to begin the revision process by consulting industry stakeholders and other interested persons prior to drafting and filing the revised regulations to Komar 20.90 and 20.95 associated with vehicle inspection standards on all vehicles currently or in the future permitted by the Commission. Staff's proposal of revised regulations was submitted on behalf of staff and the working group on August 2nd, 2021. A public comment period was held open until August 26, 2021. The proposed revised regulations require that after July 1st of 2022, a vehicle owner, transportation network operator, or transportation network company, upon application for a vehicle permit and annually thereafter, shall self-certify the vehicle complies with any vehicle safety recalls issued by a vehicle manufacturer and posted online by the National Highway Traffic Safety Administration. It's under Section 49 of the U.S. Code 30118. Currently, the Public Utilities Article, Annotated Code of Maryland, and Title 20 of the Komar requires all vehicles transporting passengers in Maryland to be maintained in proper physical and mechanical condition in order to provide safe, adequate, and convenient service. The inspection program for vehicles regulated by the Commission has been and continues to be one of the most important regulatory tools that the Commission has implemented to ensure that carriers operate safe vehicles. While the inspection program is as much as a preventative maintenance system for the carrier as it is its own enforcement system, the Commission's inspection program works. However, vehicle safety recalls have never been incorporated in any Commission inspection requirements, nor are they currently included in the Maryland State Inspection Program. The proposed revisions to Komar Regulations Title 20, Subtitle 90, Chapter 2, Regulation 16, and Title 20, Subtitle 95, Chapter 1, Regulations 11 are attached to staff's filing made on August 2nd, 2021 as Exhibit Number 1. The proposed revisions to Komar address the issues of taxis operating while subject to open vehicle safety recalls, and the proposed revisions to Komar 20.95.01.11 address the issues of passenger for hire vehicles operating while subject to vehicle safety recalls. And just to further clarify, it's the revisions to Komar 20.90.02.16 that address the issues of taxis operating. The proposed regulations require a vehicle owner, transportation network operator, or transportation network company to self-certify upon permit application and annually thereafter that the vehicle is not subject to any open safety recalls issued by NHTSA under Section 49 of the U.S. Code 3118. If a vehicle is subject to an open recall and the parts are unavailable, once the parts become available, the vehicle's recall may be remedied as soon as practical, but not to exceed 90 days from availability of the parts. The safety recall standards are an efficient and effective way to reduce the risk of having taxis and passenger for hire vehicles operating while subject to vehicle safety recalls, while also minimizing the disruption to the transportation industry in Maryland. The revised regulations are a product of the working group meetings and were drafted with input from the RM74 work group. Staff held work group meetings as directed by the Commission's order, and the work group stakeholders included the Motor Vehicle Administration, Maryland Limousine Association, Washington Metropolitan Area Transit Commission, the Maryland Public Service Commission, the National Highway Traffic Safety Administration, Uber Technologies, Inc., Z-Trip, Center for Auto Safety, the National Safety Council, Lyft, Inc., and Freedom Services, LLC. The RM74 work group unanimously recommended making this permanent rule change and agrees with staff's proposal. Additionally, Uber and Lyft filed comments, as well as the National Safety Council, the Center for Auto Safety submitted comments supporting the proposed rule changes to Komar 20.90 and 20.95 during the public comment period. Staff respectfully submits RM74's work group proposed revisions to Komar 20.90 and Komar 20.95 and requests the Commission issue an order to adopt the proposed regulations. Thank you for your time and consideration.
Thank you, Ms. McErlane. I believe we have some other parties that wish to speak. Does a representative from the Center for Auto Safety wish to speak?
Yes, thank you.
Mr. Brooks, please state your name and proceed.
Good morning. My name is Michael Brooks, and I'm testifying on behalf of the Center for Auto Safety. The Center thanks the Maryland Public Service Commission for holding this hearing on administrative docket RM74, which is the staff's proposed changes to Komar 20.90 and 20.95. The Center has been the nation's premier independent nonprofit consumer advocacy organization dedicated to improving vehicle safety, quality, and fuel economy since 1970. We are based just over the border, the Maryland border in Washington, D.C. We're appearing today to urge the PSC to approve these revisions to better protect Maryland residents and visitors from the potentially deadly dangers of recalled motor vehicles for hire. Importantly, motor vehicles are only recalled when there is a safety defect or a vehicle is in violation of a federal motor vehicle safety standard. Unrepaired recalled vehicles are a direct contributor to crashes that kill and injure innocent victims. The National Highway Traffic Safety Administration considers every recall to be a serious safety threat, and recalls are never undertaken for purely cosmetic reasons. Yet, under the current regulations, potentially thousands of Maryland residents and visitors are unknowingly and unnecessarily exposed to these deadly risks every day. And these are not theoretical risks. Today, there are over 53 million cars with open recalls across the country. These recalls include things you've probably heard of, like exploding Takata airbags, which have caused about 37 deaths and hundreds of injuries. And General Motor vehicles with faulty ignition switches, even they were recalled in 2015, still remain on the road unrepaired, and that has caused about 174 deaths in the United States. Many of these vehicles continue to operate unrepaired on Maryland roads, and we believe there's no reason that a consumer expecting safety from a commercially licensed, state-inspected vehicle for hire should be subject to such an unavoidable risk. As you know, the PSC convened a working group made up of a wide variety of stakeholders, including the center. While determining whether a recall has open recalls is as simple as running the VIN number against the NHTSA's public database, the working group was concerned with providing sufficient time for vehicle owner compliance, particularly considering the commercial nature of the vehicle's use. It should also be noted that recall repairs are required by federal law to be free of charge to the vehicle owner, so that's not a barrier to repair. The staff proposal strikes a compromise intended to require repair but allows sufficient time for that repair to be made. And the revised regulations would require that upon original licensure and annually thereafter, for-hire vehicle owners may not operate or permit the operation of their vehicle if it has open safety recalls. Both sections also provide a 90-day grace period if repairs are not immediately available. Independent studies have found recall rates in taxis and rideshare vehicles in cities around the country range from about 17 to 33%. And the proposed revisions to the code would make repairing these dangerous vehicles a prerequisite to operation, greatly improving taxi and transportation network operator recall repair rates, and also significantly reducing their risk to everyone on the road in Maryland. So in conclusion, vehicles for hire with open recalls pose a serious but preventable safety risk for drivers, passengers, and pedestrians in Maryland. And we urge the PSC to approve the revisions and continue the state's leadership in this vital public safety area. Thank you for your time and attention.
Thank you, Mr. Brooks. I now recognize counsel for Lyft Incorporated and Uber Technologies Incorporated.
Thank you, Mr. Chairman. For the record, Russell Frisbee appearing this morning on behalf of Uber. Present on the line are Varun Jain and Nasha Hopkins, who are counsel for Uber. Mr. Jain will be testifying on behalf of Uber.
Thank you, Russell. Chairman, may I begin? Thank you. Thank you, Mr. Chairman. Chairman Stanek, Commissioners. My name is Varun Jain, and I'm a counsel at Uber. Thank you for the opportunity to present our views on the staff's proposal. Uber supports efforts that enhance the safety for drivers, passengers, and the general public. We recognize that vehicle safety recalls are an important road safety issue, and consequently, Uber supports the spirit and the intent of the staff's proposal. We believe, however, that the proposal creates some complicated safety trade-offs, and we urge the Commission to fully consider those trade-offs as it determines its next steps. I'll discuss our commitment to safety, the proposal's trade-offs, the incongruent use of the federal standard, and finally some options we hope the Commission considers. As part of our commitment to safety, Uber published a first-of-its-kind comprehensive safety report in 2019. The report shares details on Uber's safety progress, processes, and data related to reports of the most critical safety incidents on our platform. I wanted to share a few important statistics that highlight the safety of our platform. In 2017 and 2018, which were the years within the reporting period, there were 3.1 million trips in the United States on Uber's platform each day. 99.9% of those trips ended without any reported safety-related issue at all. And only 0.0003%, that's 0.003% of trips had a report of a critical safety incident. Finally, the Uber-related motor vehicle fatality rate for 2017 and 2018 is about half of national rates. As these statistics demonstrate, trips on the Uber platform are a reflection of our commitment to safety. And as we wrote in our comment, numerous studies have found that our platform provides significant safety benefits, especially with respect to alcohol-related incidents that are sadly still too prevalent on the road. For example, a study in the Journal of the American Medical Association determined that Uber's introduction to the Houston market resulted in a significant reduction, 23.8% during peak trauma periods, in motor vehicle crash trauma. We urge the Commission to consider these benefits when reviewing the staff proposal, which could result in fewer TNC vehicles that are able to provide residents and the visitors to Maryland an alternative to driving drunk. And as we explained in our comment, there are two key types of crashes relevant to understanding the effects of the staff proposal. The first is when the driver is a critical reason, and the second is when the vehicle is a critical reason. Uber's safety benefits apply to the many crashes attributable to driver choice and human error. And those crashes constitute the vast majority of incidents, 94% according to a 2015 NHTSA study. And in contrast, the benefits of the staff proposal seemingly apply directly to the very small percentage of vehicle-initiated crashes, which is at most 2% according to the NHTSA study. Earlier studies also support this view, including a NHTSA Commission study from 1999, as well as a DOT contracted study from 1979. In the 1999 study, the writers found that 99% of crashes investigated a driver behavioral error caused or contributed to the crash. And the 1979 study found that human factors were cited as a probable cause in 92.6% of accidents investigated, while behavioral factors were identified as a probable cause in 12.6% of accidents. So, from our perspective, I think we can genuinely say there's a safety trade-off the proposal could create, and we hope the Commission takes that into account, as well as any foregone economic benefits as it considers next steps. I also want to touch upon the standard that the Commission staff is using. The vehicle recall standard, from our understanding, is a federal standard for notice. And the idea is a manufacturer, once a vehicle is subject to a recall, has to tell a vehicle owner that their car has an open recall. It doesn't forbid the operation of the vehicle. And using it in that way appears inconsistent with what the standard was intended and used for, which is notice only. As NHTSA and Maryland's own MVA recognize, notice is a powerful way to help drivers understand when their vehicles have open recalls. And we believe the PSC could build upon the MVA's successful 2017 recall notice pilot. Alternatively, the Commission could require TNCs, taxis, and other for-hire vehicles to educate drivers on a quarterly basis about the reasons to remedy open recalls and how to do so. Finally, if the Commission considers issuing the staff proposal as a proposed rule, we would first encourage the Commission to a little more formally assess the safety and economic trade-offs. We appreciate the Commission's consideration of our views and attention to this important topic. I also wanted to touch upon just a couple of points that other folks have made. And the first is about the ease of figuring out whether a vehicle has an open recall. It is true that as an individual, you can put in your VIN number on NHTSA's website, but it's a little harder to do that in bulk, and we can't do it in any reasonable manual way on NHTSA's website. And if you take a look at NHTSA's API, that actually doesn't allow you to put in a VIN number to get whether there's an open recall on a vehicle. And the other point I want to make is that we recognize that recall repairs are free, and we think that's great public policy, but there's distance involved, there's time involved, and that is not free, especially for the folks who are operating on our platform. Thank you so much.
Thank you, Mr. Jane. Seeing no additional parties wishing to speak, I'll just start with one quick housekeeping matter. And this is for Ms. McErlane. Ms. McErlane, at the time the work group convened and staff made its proposal to the Commission, was this a consensus product?
Yes, the work group agreed to what staff filed on behalf of the work group.
Mr. Jane, do you agree with Ms. McErlane?
I have a different view. In fact, we sent an email to the PSC staff indicating that while we agree with the spirit and intent of the proposal, we don't agree with the specific language. We offered some suggested edits to find to develop a proposal that is more in line with the goals that the PSC had, but we never agreed that this was a proposal that we wanted. And we actually submitted comments very similar to the comments that we presented to you today, Mr. Commissioner. We submitted those comments to the PSC staff.
Did you have the ability to look at the proposed regulations in the work group prior to their submission on August 2nd?
Yes, we did.
And you did not agree with those regulations?
That's correct.
Ms. McErlane, can you help me connect the dots here?
We circulated the proposed regulations. Uber made edits that we incorporated to the proposed regulations. And from those meetings and discussions again on the proposed regulations, the work group supported the regulations and they were filed on behalf of the work group.
Okay, apparently there's a misunderstanding somewhere along the line, so I will consider these to be a non-consensus work group product with the objections, or maybe I'll state it as suggestions as articulated by Mr. Jane in the comments and his statement just now. Let me turn to my colleagues for questions of the parties, beginning with Commissioner Herman.
Good morning. Ms. McErlane, I have a question about compliance with this regulation. What kind of compliance function, or not compliance, I mean enforcement, what kind of enforcement function do you think the commission can or should be doing with respect to this addition in regulation?
Well, compliance of this rulemaking would fall under first when a taxi cab or TNC applies to receive their license, they would self-certify that they will fix any open recalls that the vehicle they're operating may be subject to. And then annually is when their vehicle is up again for inspection, they would self-certify that their vehicle is not subject to open recalls.
Right, I apologize. I shouldn't have used compliance. I mean enforcement. What kind of enforcement activity, if any, do you imagine or would you expect the commission to be doing with respect to this change in regulation?
Ma'am, do you mind, Mark Gorman, Assistant Director of Transportation, do you mind if I answer that the best I can?
I do not. I was just about to suggest that that you were looking like you wanted to answer that question.
I was thinking of what I wanted to say, but yes. Good morning, everyone, Mr. Chairman, Commissioners. We're looking at, obviously they haven't been, the regulations haven't been, they're just proposed and they haven't been accepted yet, but our thought process is that there's going to be an audit in place that kind of mirrors what we do with the inspections. We have annual reports, accessibility reports, and inspections that are due on an annual basis, and they are submitted by the carrier companies and the taxi cab companies. So what we're thinking is that it's going to kind of mirror that, and we're going to have some form, whether it's an electronic form or paper form initially, and they're going to submit it, obviously, in order to put the vehicle on a permit, and then annually thereafter. So how the enforcement side of it, we're looking at running audit, and then we really haven't gotten into how we're going to exactly do it, but if kind of mirror the inspection, we request an inspection certificate on a certain date. If the inspection certificate is not submitted, then we reach out to the company, and then if it's still not submitted, then we do issue a citation for failure to submit the inspection. So we're thinking along the same lines as that, as if they fail to submit a report that we've requested, then we will issue a citation based off of that.
And is that citation to the driver?
That will be to the owner of the vehicle.
The owner of the vehicle. Okay. So would then you say, okay, you have 30 days to get that recall addressed, or would there be a time period, or how would that work?
Well, the way I'm thinking too, if with the caveat or with the exemption for the 90 days, this is going to have to be on a case-by-case basis. If we do determine or identify someone that, okay, we've requested this self-certification and we haven't received it, and then we go through, and this would be on the investigative side. I'd have to look into whether or not there is a recall, whether or not the recall has been accomplished, whether or not the part has been is available, when it became available, and then if they're just ignoring us. So it's going to have to be a case-by-case basis in that situation. As far as the self-certification, I really haven't gotten too far as to if I guess it would depend on how many self-certifications we're not getting, and it would probably mirror the inspection, because we're going to try to attach that with the annual inspection request. So them submitting the annual inspection request is going to kind of mirror the self-certification request.
Okay, and so you're not really auditing whether they've done the safety recall. You're more auditing whether they've done the self-certification, at least at first.
Correct. Yes,
Okay.
ma'am.
Okay, and is there any, is it helpful for you all in the transportation division to have dates? Like, do you want the annual, you certify the first time and then the annual certification comes on a particular date? Or is it better to have them just rolling with all the other certifications? Because it seems to me, I don't know if it's easier for you all to get them, say, on January 1st or June 30th, and they all come in at the same time, or, because that's a lot of work for you all to be checking all these, did somebody send in a self-certification? So trying to would it make the job easier if there were a date, or would it not?
No, absolutely. So that's a good question, because when for insurance purposes, let's say, when we request the insurance or certificate of insurance, that's on a monthly basis. So we run those each month, and then because the insurance expires all different times. But on the inspection side, what we have done over the last few years is we've gotten to the point where we can request them at the same time. We'll send out a request in March, and we'll say, hey, this has to be in by the end of June. So everybody, and what we're trying to do is we're trying to get all the carrier companies, taxi cab companies, kind of learning that, hey, they're gonna start requesting these. They're gonna start looking for these. Let's start getting these inspections done. So we're thinking that it's gonna mirror that they'll have the opportunity to say, hey, this is about the time of year is when they're going to start asking for my self-certification. It's the same date every year. And that's our thought, is that we'll try to do it that way.
Okay, right. Okay, my next question is for Mr. Jane or Mr. Frisbee, whoever wants to answer. Does Uber have any kind of guidance or suggestion to its drivers to encourage compliance with safety recalls?
Yeah, thank you so much. And we do. So we take a number of steps related to open vehicle recalls. First, our platform access agreements, which every driver has to agree to, they explicitly require users to check for and cure recalls. Second, under our community guidelines, we state that drivers have to maintain their cars with brakes, seatbelts, and tires in good operating condition and according to industry safety and maintenance standards. And third, we actually do send communications quarterly to drivers saying, hey, open recalls are an important issue. Can you please get them checked out? Go to the NHTSA website, put in your VIN, and take a look. So we do a number of things related to open vehicle recalls, because we agree with many of the participants on this call that they're a genuine issue. I think in this specific case, we have some questions about the safety trade-offs.
Okay, but did I hear you say that you require compliance with recalls, that people, when they're signing up to be a driver, say that they're going to address the safety recalls? Did I hear that?
Yeah, our platform access agreements, and drivers have to agree to those agreements. Have to agree to the platform access agreement. They do explicitly require users to check for and cure recalls.
Okay, so if it's already required, what's the problem with this regulation then? Because if it's already required in your platform access agreement, I think that was what it was called, why is this regulation so problematic for you?
Yeah, absolutely. I think the the challenge is that this regulation would actually prohibit the operation of vehicles if they don't have a recall cured. And that's not exactly what our platform access agreement does. Our platform access agreement says we have an agreement, and we can take steps if we want to, but we are saying this is our expectation of you. And so these vehicles could still drive with open recalls, but drivers understand the expectations that they're under when they agree to those platform access agreements.
So it's okay for you to, it says you've got to, you're supposed to comply, but it's okay if they don't comply?
I would say that under our view, there are lots of specific provisions of platform access agreements within the platform access agreement. And if a rider, for example, or even a driver mentions that they have an open recall on their vehicle, we will investigate and take appropriate steps. So I think we're sort of in the intermediate area of where it's just something that's aspirational and something that we always take a step on with respect to the agreement. Here, we think the regulation would be a little different. As we understand the regulatory requirement, there is a prohibition on a vehicle with an open recall operating after the date of self-certification. And I think that's the difference. The 20 to 30% of vehicles with open recalls in the United States would not be able to operate on the platform.
And okay, thank you, Mr. Chairman. That's all I had.
Mr. Jane, you just said something very troubling to me, at least the way I interpreted it. You said effectively safety recalls are aspirational for Uber. So you require under this agreement that your drivers adhere to the requirement, your words, the requirement that they comply with all safety recalls. And in response to Commissioner Herman, when she asked what happens if they don't, you seem to suggest that there's a lot in the agreement and Uber doesn't enforce it. It appears that our proposed regulation would simply mirror the requirement in Uber's agreement. Can you explain it? Is there a distinction or discrepancy here, or is it the same requirement?
Yeah, I appreciate the question, Chairman, and I think there is a distinction, and I think what I said before is that there is a platform access agreement, and we do take steps to enforce a platform access agreement. As an example, there are a category of recalls called do not drive recalls, and we monitor weekly to make sure that vehicles with do not drive recalls do not operate on the platform. That's a weekly process. It's a manual 8-step process. And so as we understand it, these do not drive recalls end up being some of the most dangerous recalls. So I would not say that the platform access agreement is aspirational, Mr. Chairman, and I apologize for misspeaking, but we do take steps with respect to these do not drive recalls.
But you're making distinctions among safety recalls. So you have the do not drive recalls, and then you have the whole other universe of recalls, which it does not appear that Uber is enforcing.
Well, again, the do not drive recalls, the recalls that notice is we understand that to be something that a person can do on their own time. They're not legally obligated to fix their vehicle, at least under the NHTSA standard. And so I think, concordant with what the federal government has said about what a vehicle recall notice means, I think our platform agreement is fairly consistent with that.
They're not legally obligated to have the recall repaired per NHTSA, but they are obligated to have the recall repaired per the Uber agreement. Is that right?
My understanding is that the agreement, I will admit I'm not familiar with all the specific contract provisions of the agreement, and we're happy to get back to you very quickly on an answer to that. But my understanding is that the platform access agreement requires users to check for and cure recalls, but there's obviously that second step of assessing whether users are checking for and curing recalls. We do that in what we think are the most the cases of the greatest risk, which are do not drive recalls, and I don't think we do that for in every single case.
So effectively, it's the honor system with Uber in terms of whether or not these other recalls are actually being repaired.
Yes.
Okay, thank you. Commissioner O'Donnell.
Thank you, Mr. Chairman. And let me just say up front, it's heartening to see such a wide range. I was sitting here thinking, should the word be panoply or should the word be plethora? But such a wide range and group of alphabet soup agencies at the federal and state level and non-governmental organizations participating in this relatively narrow rulemaking in the big scheme of things. And it's an important rulemaking, but it's good to see so much engagement from so many different corners above and beyond the financially interested stakeholders. So, Mr. Jane, I'm going to start with you. Staff counsel says that Uber provided edits to the proposed regulations. Did you consider giving edits to language that would support your support of the spirit and intent of these regulations? Did you consider that at all? Let's provide some language that would make us satisfied.
Yeah, we had asked the rulemaking staff. We actually, I think in our original comment, we mentioned to the rulemaking staff.
Wait, excuse me. Who is the rulemaking staff?
Oh, I apologize. The staff that developed the proposal.
The Public Service Commission staff. Okay.
Yes.
They work for the commission. Okay, go ahead.
Yes. We had discussed with the staff and suggested a few different options in our initial comment, and we mentioned that we were happy to work with the staff to provide language for those options, but our understanding is that the staff was interested in the language you see before you. I believe a few days I can find the exact date for you. It's on July 28th. We sent some additional language to the staff after a discussion, and our understanding is that the staff wanted to continue along with the proposal generally as written, and we said, well, we think it doesn't meet the goals and the intentions that you staff have, and if you would like to continue with the proposal based on how you've interpreted language, we would make a few revisions. So we provided those revisions on July 28th, 2021, but we have said that, I think at the end of our email, we said, well, we have other observations expressed on the call earlier, including some of the unintended consequences that may occur where the rule issued. I wanted to keep this email to what you intended the language to allow. So we've provided some additional language to the staff, but they did not seem interested in the language with respect to the options that we thought about. We did get an email from Ms. McErlane on this past Thursday asking for specific language for the options that we proposed. But our internal process, I think before the Labor Day weekend, would not have allowed for a thorough and thoughtful language to be drafted. But we are very happy.
So, Mr. Jane, what it feels like to this commissioner is you're saying we agree, Uber agrees with the spirit and intent, but we want the Public Service Commission to come back with language that satisfies us. That's what it sounds like to me. And that to me is rather offensive, I have to say, because the normal process, the commission is the decision maker, not the staff. The staff is an interested party in a proceeding, in a rulemaking, but they are not the decision maker. And you should be presenting that language to us. Mr. Frisbee well understands this as a former member of this commission and as a former chairman of this commission. Isn't that right, Mr. Frisbee?
Yes. I'm a bit in an awkward position because I was not part of those negotiations. I do understand that, at least from Uber's perspective, its general sense was that its overall recommendations were going to not be put forward by staff, so it attempted to do the best it could, I guess, make the best of what it saw as a bad situation. But
Yeah,
again, that's,
But the reality is, staff doesn't put Uber's recommendations forward. Uber puts Uber's recommendations forward, as you well know, and we make a decision. Sometimes we agree with staff, sometimes we don't, but staff is not the dispositive decision maker. The commission is, right?
I would agree, Mr. Commissioner. As I said, I'm in an awkward situation because I was not part of those negotiations.
Thank you. I accept that. I respect that. I want Uber to understand that in a rulemaking process, interested parties can bring language, and actually it's incumbent upon stakeholders to bring different language to the commission, not ask the commission to provide different language based on your conceptual, here's what we'd like to have. And I wanted to make that clear.
Commissioner, I apologize, and I appreciate that. I'm very happy to provide language for the commission's consideration. I will not be able to do it at this moment, but we are very happy to provide language as quickly as we humanly can.
Let's see if this ship has left the shore yet and it's too late to get on board. I don't know. We'll see, Aaron, shortly. Thank you.
Commissioner Linton, good morning.
Morning. Thank you, Mr. Chairman. Good morning, everyone. I had a couple of questions for Uber and Lyft regarding the three options that were proposed on pages 7 and 8 of your comments. I think Commissioner Herman and her questions addressed option 2 for me. I wanted to make sure I understood what you were intending to achieve with options 1 and 3. Starting with 1, my understanding of it is you intend to recommend that as part of the normal inspection process, the MVA provide notice to the vehicle owner of an open recall at the time of that inspection or shortly thereafter. So my question to you is, are you suggesting that that option replace the proposal that we have in front of us now before the commission, the proposal that was made by the commission staff, not just for the notice requirement, but for the prohibition for using the vehicle if the recall is not addressed?
Yes, Commissioner Linton.
Okay, so this notice requirement seems similar to the one that you were discussing earlier with the chairman and Commissioner Herman. Am I correct in stating that?
Yes, Commissioner.
Okay. So there wouldn't, under the proposal of option 1, if the if the driver is or vehicle owner for some reason doesn't take action when they receive that notice of information, either from Uber or Lyft or from the MVA, they can continue using the vehicle without any notice to the commission or anyone else, or taking any action at all beyond the actions that are required as part of the agreement that they have with either of your companies.
Yes, Commissioner, and we believe that is consistent with the federal notice standard that for these open recalls. The federal standard doesn't require a prohibition, and in our view, providing notice, which we are certain that works, is an effective approach, especially because of the safety trade-offs that we identified in our comment.
Okay, so do you know if the federal requirement takes into consideration that the vehicle owner may be using the vehicle to transport other individuals that are not the vehicle owner?
Yeah, so my understanding of the federal requirement is that it applies to every type of passenger vehicle. I understand it applies to light duty trucks and some other vehicles as well. And so there are recalls for vehicles that transport others. And for example, I know that there are recalls for school buses.
All right, thank you. Now for option 3, I'll use the words that you have here. Formally assess the safety trade-offs of the staff proposal. Can you help me to understand what you're suggesting? Is it just that there will be a number of vehicles that might not get recalled and get their work done, and as a result, they be removed from the road, and that has some economic impact as a result. Is that generally what you're referring to?
Thank you for the question, Commissioner Linton. It is that and a little more. Our understanding is that, and based on several NHTSA studies, the vast majority of crashes are human caused, and Uber reduces the likelihood of those crashes from occurring. A very small percentage of crashes, 2% according to a 2015 NHTSA study, it's where the vehicle is the critical reason. And in our view, those 94% of crashes, many of which our service helps reduce, those should be taken into account when thinking about prohibiting vehicles from operating on the platform. So Commissioner, it's not just the economic harms, but there's also a safety trade-off that we believe that the rule is making, because while there may be some benefits with respect to the number of vehicle-related crashes, so because of a defect, we believe, based on the studies that we've provided, there will be harms because there'll be fewer TNC vehicles operating. So for example, if someone is drunk and wants to get a safe ride home, they'll be less able to do that. And so those are the trade-offs that we are talking about when we're thinking about assessing the costs and benefits of the rule.
Commissioners, this is Kenneth Albert on behalf of staff. Can you hear me?
I can, yes.
I just want to respond again, because Uber keeps on going back to this argument. They are called the unintended consequences. They call it the safety trade-offs, essentially saying that a ban on open recall vehicles, ban on operation of those vehicles, would significantly reduce the availability of for-hire vehicles and could somehow result in an increase in impaired driving. I'll be frank with you, when I first heard this argument, I was a bit shocked, frankly. I was like, that can't be your main argument, but it really is, as they've repeated it, and really that's the only argument they are presenting. Implicit in this argument, ironically, is the fact that a lot of open recall vehicles are currently in operation, because if that would the only reason they would be concerned about a significant reduction in the vehicles would be that so many of them are in operation despite an open recall. Also, I mean, this is real speculation. I mean, if there's a ban on the use of open recall vehicles, this gives the drivers a strong incentive to get the vehicles fixed once they become aware that the vehicle has been recalled. And in fact, earlier on, we had the issue of how Uber could find out that whether there was a ban, and you have to go onto the NHTSA website. My understanding from our prior conversations with the TNCs was there was some availability, I should say, on the NHTSA website to input a package of VINs. So it's not like they have 250,000 vehicles and they have to insert each VIN number one after another, each separately. My understanding is they can establish a software package so they can do it in one button. But getting back to their argument, again, this trade-off, the safety trade-offs, you also think if there's a ban, they say if this ban reduces the number of vehicles, which again is speculative, then people who are impaired by drugs or alcohol are going to go ahead and drive because, well, they call up for an Uber and they're told that's not available. There's no car. First of all, there are fairly severe penalties for impaired driving. So it's entirely speculative that people will say, gee, I can't get an Uber, I'm going to get behind the wheel. Also, is it possible that'll happen? Sure. But in that instance, that's where the Maryland legislature steps in. They have responded repeatedly by tightening these drunk driving laws. And for example, in 2016, they passed a law, the Drunk Driving Act of 2016, Senate Bill 945, that significantly expands Maryland's ignition interlock program to help keep drivers off the road. And ignition interlock is a device that prevents a vehicle from starting when the device detects a certain level of alcohol in the driver's breath. So this law indicates that if we do, in this speculative situation, but sure, it could happen, that there's a significant reduction in the availability of these unsafe vehicles because of a ban on use of open recall vehicles, and there's a spike in impaired driving. we would hope that the legislature, and we would expect the legislature would step in, because they typically respond to that kind of change in circumstances. Also, I just want to, in page 2 of their comments, and Uber's repeated it now, they say that only 2% of crashes are due to defects in a vehicle. According to NHTSA data for 2019, 6.8 million vehicle crashes were reported to the police in 2019. So if you take 2% of 6.8 million, you get 135,000 crashes due to vehicle defects. And that's a fairly large number. Uber repeatedly notes that, well, the feds don't ban the operation of open recall vehicles, so therefore, well, the states shouldn't ban the vehicles. There's no preemption there. There's no argument there that somehow the states are prevented from responding to what is clearly a loophole in the enforcement of the open recall mandate. So staff view is, because of these safety hazards posed by the operation of an open recall vehicle, the proposed regulations would address this problem and would do it in a, we believe, in an effective way. Thank you.
Mr. Chairman, may I respond?
It was Mr. Commissioner Linton's question, but Commissioner Linton.
Sure, why not?
Thank you, Commissioner. And as you can tell, this is my first time, and I apologize for any hiccups. So the first point I'd like to make, and I appreciate Mr. Albert's comments, is that there are a number of studies that support the view that the vast majority of crashes are caused by or have a contribution related to human error, and very few crashes are related to vehicle defects. In fact, I believe in after the study, the NHTSA study that I cited from 2014, in 2015, and let me see if I can find it in my notes, I think NHTSA actually characterized that specific study. And here is the quote. Here's how they characterized that study. And this is a statement of principles issued during the Obama administration. In 2014 alone, 32,675 people lost their lives to our nation's roadways, with 94% of all crashes attributable to driver choice and human error. Most of the other 6% of crashes were the result of environmental factors and improper maintenance, with auto defects being identified as a unique cause in less than 1% of those cases. And so we think that auto defects are, like as Mr. Albert's suggesting, are a genuine safety risk. It's just that we think there are safety trade-offs that it doesn't appear that the staff has fully considered. As to the point about using an Uber for drunk driving, to avoid drunk driving, our view is that's not speculative, and that's based on surveys that are performed that we have highlighted on page 5 of our comment. And I'll just read it here. The survey also highlighted the credit people give TNCs for improving safety in their cities. 88% of respondents agreed with the statement that Uber has made it easier for me to avoid driving home when I've had too much to drink. And 78% of respondents said that since Uber launched in their city, their friends are less likely to drive after drinking. So again, we do think there's a genuine trade-off here. And the final point I'd like to make is it's not just that that there's a safety trade-off, but it's also that the standard that's being used is a standard that the federal government uses for notice. The federal government doesn't use a standard to prohibit any vehicles from operating on the road. There are different gradations of vehicle recalls, and we recognize that those do not drive recalls. I believe those are about 6% of vehicle recalls. We believe that those recalls, present a greater risk of harm, and we have prohibited vehicles with those types of recalls from operating on our platform. And I think you can get to see why the federal notice standard doesn't quite work in this context based on the example we provided in our comment. So if you take a 2018 vehicle that has, there's an obligation, there's a federal motor vehicle safety standard that requires rear view cameras. And in some of those cases, there are defects on rear view cameras. And I have a 2021 Subaru Outback, there's a defect on the rear view camera. So those vehicles would not be able to operate. 2018 vehicle with a defect in the rear view camera would not be able to operate. Whereas a 2017 vehicle, which doesn't even have the camera, would be able to operate. In our minds, those vehicles are very similar to each other because neither of them has a rear view camera you can use to look behind you, but one of them, under the staff proposal can operate while the other cannot. And I think that gets to our view of why the federal notice standard doesn't appear to be the right standard to apply when you're actually prohibiting vehicles from operating on the platform.
Thank you, Mr. Jain. And I just have one additional question for either you or for Lyft. In your efforts to provide notice to your drivers on a quarterly basis regarding the potential of any outstanding recalls, are you able to track, or have you been tracking the results or responses for those notices? In other words, when your drivers receive those recall notices from you, are they responding and getting them fixed?
Commissioner, I don't believe we have monitored that specific issue. And part of the reason is that it is the case that you can put some amount of VINs in bulk into the NHTSA website, but not the number of vehicles that we're talking about here. And we've looked into the API, the interface that we would use to automate requests in NHTSA, and our understanding, and this I've talked to the technical folks, our understanding is that it does not allow you to submit a VIN to see whether there's an open recall. And the last point I just want to make is that under federal law, manufacturers are legally obligated to provide recalls for to cure recalls for free. But you don't have to go to a manufacturer, and especially I imagine in rural areas. You don't have to go to a dealer. And I imagine in rural areas, it's actually not that easy to get to a dealership. So you're going to have to find some other way to do it. Now, maybe what you do is you go to a local mechanic. I could see that happening. But that local mechanic has no obligation to report to NHTSA. And so the NHTSA database, there's not a guarantee that the NHTSA database is going to include all cured recalls for a particular VIN.
Okay. Thank you, Mr. Jain, Ms. Hopkins, and Mr. Elbert. And thank you, Mr. Chairman. That's all I had.
Thank you, Commissioner. I have a few additional questions for Mr. Jain before I wrap up. Mr. Jain, I'm in full agreement with you that the federal standards do not prohibit the operation of open recalled vehicles. So if I had a private vehicle that I wanted to drive, but not get the recall taken care of, I could do so. But we're talking about for-hire vehicles where members of the public will be stepping into this privately owned vehicle, but not know if there's a safety recall. You've already stated that Uber requires through its agreement that all safety recalls be completed. So I still fail to see a lot of daylight between this, or any daylight between this proposed regulation and what Uber requires of its vehicle drivers. I also did not find that example you just provided regarding the 2017 and 2018 vehicles persuasive at all. If the 2018 vehicle has additional safety equipment, it should be operational regardless of whether or not the 2017 model equipment had that safety equipment installed. In what city is Uber headquartered?
We're in San Francisco.
And in San Francisco, who is the regulator that regulates taxi cabs in San Francisco?
I'm not sure of the local regulator.
Okay, I believe it's the San Francisco Municipal Transportation Agency. And in your home city of San Francisco, isn't it true that all taxi cabs are subject to this regulation that commission staff is providing today?
Well, we have tried looking for the specific language that imposes that requirement, and we've asked commission staff. We are happy to take the staff at its word, but we have not seen that obligation. And our understanding is that's the only place in the United States where that's the case with respect to public for hire vehicles.
So you've not seen the regulations, but you believe that they are true?
I think we are taking the staff at its word.
Are you enforcing the San Francisco regulations?
We don't have taxi cabs on our platform, so those regulations are not for transportation network company vehicles, but specifically for taxi cabs. Sharon.
Okay, so they only apply to taxis and not Ubers and Lyfts.
Yes, sir.
With respect to option number 2 on your proposal, sort of education of drivers on a quarterly basis, you state that Uber currently does that. Is that correct?
Yes, Chairman, that's correct.
Okay. Why would you then be requesting the Public Service Commission to require that Uber educate its drivers when Uber is already doing so?
Well, I think that we are talking about every TNC in Maryland and not just Uber. We're not sure what other TNCs do or do not do. We think a notice is a powerful and effective tool to help folks know when there's an open recall on their vehicle, and we are very happy to raise the bar with respect to other TNCs doing the same thing.
So you view this as a best practice for other TNCs?
Yes, sir.
Do we have counsel for Lyft here today? I recognize you only represent Uber. Is that correct?
Yes, Chairman, that's correct.
But it's my understanding that counsel for Lyft joined you on the responsive comments. Is that correct?
Yes, Chairman, that's correct. They did join us on the joint comments.
Okay, thank you, Mr. Jane. Unless my colleagues have additional questions, I am prepared to make a motion. I see no additional questions. I would note that in reviewing the staff's proposed regulations, which are identical for the chapters both with respect to taxi cabs in Chapter 2 and with respect to TNCs in Chapter 1, there is a formatting error, which I believe can qualify for edits under Komar drafting requirements. But I will point this out to the team. So Mr. Albert, Ms. McErlane, please pay attention. With respect to regulation number 7, you propose a 7A and 7B. Do you see that, Mr. Albert and Ms. McErlane?
Yes.
Okay, thank you. The 7 provides an exception at the end. Exception if : that only applies to A. That does not apply to B. B is a separate regulation effectively on its own. So 7 should be extended by striking A, and then item B would have to be reformatted either as a new regulation 8 or something else. But that's something that the Komar drafting people could pick up. Do you concur, staff counsel?
Yes, I concur.
Thank you. We appreciate the comments of staff, the comments of Uber. Mr. Jane, I recognize it was your first time to the commission, so welcome. And Mr. Brooks on behalf of the Center for Auto Safety. However, hearing the testimony today, I am convinced that the safety outweighs any of these other trade-offs as Uber describes. This staff proposal merely requires what at least Uber already requires of its drivers, and in the event that parts are not available, the individual owner of the vehicle has an additional 90 days until such time when parts do become available to get this recall completed at no charge to the vehicle owner. For these reasons, I would move that the commission publish the following draft regulations as proposed by staff on August 2nd, 2021 in the Maryland Register for public notice and comment, subject to non-substantive changes as discussed, necessary to conform to Komar drafting requirements. And this is with respect to Title 20, Subtitle 90, Chapter 2, Regulation 16, and Title 20, Subtitle 95, Chapter 1, Regulation 1. The vote begins with Commissioner Herman.
Thank you, Mr. Chairman. I vote aye. I would note, though, that to Uber, this is a publishing of a draft regulation, and as Commissioner O'Donnell noted, if you have proposed changes that make sense to you, you have the opportunity to provide those comments to us. So, I want you to be aware that you still have the opportunity if you have changes that you can propose them. However, It does also sound to me like your platform access agreement, which we haven't seen, but does appear to already require this, as well as that you already tell people that they need to comply with the do not drive recalls, and I assume you take them off of the platform if they don't comply, and you do that weekly. So I think there's some additional information that you could potentially provide to us, perhaps if you wanted to continue to try to persuade us to limit this in any fashion. So my vote is aye.
Commissioner Linton.
Thank you, Mr. Chairman. I just have a friendly amendment. I also vote aye. But your earlier comment regarding the revision in section in part 7 also applies to 20.90.02.16I. It's the same exact language, same issue.
Yes, Commissioner Linton, duly noted. I neglected to mention that. Correct. Thank you.
All right, friendly amendment, aye.
Commissioner O'Donnell.
I vote aye, of course, but if we're amending, are we amending the chairman's suggestion and Commissioner Linton's suggestion? Because if we are, we got to go back to Commissioner Herman and get her to agree to it.
Oh, no. Yeah, I concur with it, but it's I agree with the chairman that it's a technical change. I don't think we need.
If it's a technical change, we don't have an issue, but Commissioner Linton kind of threw my process antennae for a loop. So, it's a word amendment.
I was a little slow in jumping in there before Commissioner Herman started voting, so.
Oh, sorry about that. I think it's a technical change.
I do too. I vote aye, Mr. Chairman.
Thank you, Commissioner. I vote aye. The motion is approved. The proposed regulations will be published in the Maryland Register relatively soon. Thank you for attending this hearing today with nothing else on today's agenda.